Hello, welcome back to Move Ahead with Dalia. On today's show, my guest is my good friend, Michael Perez. He's an attorney here in Chicago, and we are discussing estate planning. Hi, Mike.
Hi, Dalia.
How are you?
Really well, thank you.
Good. Thank you for being here.
You're welcome.
So, October is National Estate Planning Month, and I thought this would be a perfect time to bring someone in who actually helped me with my estate planning and can explain a little bit about the estate planning process. But before that, I would love for you to just give us a brief idea of what estate planning means.
Well, estate planning is the process where you figure out what you want to do with your stuff.
Okay.
And who do you want to be in charge of it once you do pass, right? If you have property, you have assets, income, and you want to know where do you want it to go. Estate planning is figuring that out in advance of, you needing it. So
Okay, good. Well, that's great. Before we get into a deeper dive on estate planning, I'd love for you to share a little bit about your background and the services that you offer.
Well, I'm a Chicago lawyer since 1986. I was in Humboldt Park for 27 years. And then we moved a little bit north and a little bit south to Humboldt Park. We've been there for 10 years. Being in the neighborhood, I do all kinds of neighborhood type things. I really like working with people instead of businesses or the like. I do that as well, but my main focus is working with people and their families. So I do a lot of family law stuff, divorces, child support, custody. I do workman's comp, I do accident cases, and I do a lot of probate work, which is the process after somebody dies. And a little bit before that, we do some estate planning, some wills, some trusts, powers of attorney to take care of the people, powers of attorney take care of you before you pass, but are unable to take care of yourself. And the will takes and the trust take care of you after you pass. And it takes your wishes and puts them into a practical plan of distribution of your estate.
Okay, wonderful. Well, I know you have a lot of services, legal services in your office. You said you started in Wicker Park?
Yes.
And you were there like 27 years, and now you're at Humboldt Park for the last 10 years.
Correct.
Okay. And do you just service Chicago, or do you service suburbs as well?
I would say about 70% of my business is local.
Okay.
In Chicago in 60622 and 60647. But
Okay.
I have many clients outside of Chicago in the suburbs. I have a couple of clients that are out of the state.
Yeah.
With the internet, I've represented people in other countries that have cases here and other states. That's pretty common these days.
Okay.
A client in Texas, one in the Arizona, Colorado, some in Florida, and for some reason, the internet helps me get those clients. So
Awesome. Well, I know we've done a lot of work together in real estate,
Yes.
right? We have mutual clients that we've closed transactions in, and I refer many clients highly to your office because I know that you and your staff have done an excellent job in the past. So I want to thank you for that, for taking care of my buyers and sellers. And of course, I appreciate that there's always that communication. I mention in many of my podcasts that communication is key, right? When we're trying to get through processes, whatever they are, and your office is excellent at that. So thank you. You helped me and my husband, Pete, with our estate planning, and it was 8 years ago. And I remember before we decided to do that, we just checked in with you and you said, come on in, let's talk about what you need. And then the second visit, you had everything ready. It was very easy. So this is one of the reasons why I wanted to bring this up on the podcast, because you helped us with that and you made it a very simple process. So what is it that you ask your clients to help them through that process when you meet with them initially?
Well, it's a good idea to know what they have and to decide whether or not estate planning is even necessary.
Okay.
Right? So I have some clients that they've situated themselves so perfectly that an estate plan, a will, or a trust is probably not even necessary. Right? You own a house; it's in joint tenancy with you and your husband, and so you don't have to worry about transferring back and forth there. You have bank accounts where you've designated beneficiaries. You have a 401k or some other retirement plan. Again, you've also named beneficiaries. You have insurance, name the beneficiaries. So there may be very little that is going to transfer outside of the family. I suppose even if you had a house and it's a transfer between joint tenants, you might still want to have a will. That is, if you wanted to leave it to your children or someone other than your children.
Okay.
The benefit of having a will in that situation would be that if it needs to go to probate and it needs to transfer to someone else, you can waive some of the fees that are in the court. The expenses like a bond fee, which can be significant depending on the value of your estate. And you can also designate who do you want to be in charge. You pick an executor. You want usually it's the spouse, and then another trusted person. It could be your oldest child, which most of the time it is, or the responsible child, I should say that. So there's usually a few in the bunch that you don't want to be in charge. So you get to choose where this thing is going, and how it's going to get there. I think that's the benefit of a will.
Okay, so you're protecting your assets, right? And you're protecting your family.
Correct.
If that's where you want your assets to go to.
Correct.
You want to make sure that it's in writing.
Right.
Okay.
Right. There's also some benefits as well, that you're making a plan that your family can see. A lot of times you get to the end of life and you've not discussed it with the family. They don't know anything about what you want, how do you want it done, and then all of a sudden you passed and they're really at a loss. Should I be in charge? My brother be in charge? What should we do with the house? What should we do with all of this stuff? Yeah, that leaves them in a quandary. And you want to make sure that you've, one, made the plan, and two, then discussed it with your family. I see a lot of times where people have come in and they have the will, and half the family's never talked about it, never seen it. They don't know that, mom picked that son instead of that daughter, and now they're really mad about it, and they feel like one of the children has overstepped a boundary and gotten their parent to do something that they didn't want to do, right? And that's a simple conversation. Mom or dad or whoever could have said, hey, all you kids, I'm putting Dalia in charge of this estate, and I want, I've got all my things written down. She's going to take care of it, but she's in charge. And instead of sometime later, they come and say, oh no, she talked him into it. She brought him to the lawyer. That's her friend. And, it just causes lots of problems if you don't talk about it. And,
Yes.
And I see, even in, not so much in my family because we've had these conversations, but other families that I know well never talk about dying.
Right.
Don't want to, no.
Don't want to bring it up.
Correct.
They don't want to, they're avoiding it.
Correct.
Right?
Right.
Yeah.
And in your example, we met once, a week later, we signed your documents, and it was all over.
Yeah.
And so it's not a big, huge thing. You can take care of these things fairly quickly.
Yeah, and I while we're on the topic, so we have the last will and testament, which is mine. This is my document. We also covered in power of attorney for healthcare. And what does that do?
Well, power of attorney for healthcare, also called a living will. Okay. You can designate who do you want to make your medical decisions, who do you want to decide things in a situation where you cannot do it yourself.
Right.
And you don't have to be old. You'd be going in for a surgery to get, something, and you're unable to make those decisions in that period of time. You want somebody to be able to do it. Or in a worst case scenario, you're in a car accident, right? You go to the hospital and there's no one there that has the legal right to tell the doctor, I want this surgery, or I don't want that surgery, or
Right.
I want you to extend their life, or, keep them comfortable, but, don't take extraordinary measures. Always a good plan to know what, your parents want or your loved ones want.
Yeah, I think we always assume that we're talking about the elderly,
Right.
right?
Right.
And it can happen to anyone,
Correct.
right? It can happen to a young person in their 20s or 30s that, got sick. We saw it through COVID, all the people that passed away.
Right.
And I'm sure many of them did not have anything planned because nobody saw that coming.
Right.
So yeah, it's important. And then the other one is the special power of attorney, which basically whoever you designate as the agent, right?
Correct.
That's the term, the agent, is the one that will have the power of attorney to sign documents on your behalf.
Well, that, and to also say, for instance, you need to call Social Security. You need to go to the bank and move around their money.
Okay.
For instance, somebody's in the hospital and they're unable to get out to do that. And
Okay.
you need to talk to anybody, creditors, banks, Social Security, any other governmental agency.
So you present this document so
Correct.
that they know that you were the one allowed to do that. You're the agent.
Correct.
Okay.
Correct. And the powers of attorney help you before you pass, right? But are unable to take care of yourself, either through injury, illness, or something else catastrophic.
Right.
Not dead, but unable to take care of yourself. And then the will and trust, they take care of you after that. So you want to cover both sides of the fence. And again, you could be young, injured, ill, or otherwise incapacitated. And those documents help.
Okay. And then to go back to elderly, you mentioned in an earlier conversation about when a client calls you and they say that their parent or, some loved one in the family has dementia. What happens if they don't have these documents ready?
Well, it's usually a problem. They call because they need help doing a thing. They want to talk to Social Security, Medicare. They want to go to the bank. They want to pay mom or dad's bills. That they need access to the money, but they don't have a power of attorney. But once you've been, declared incompetent or mentally unfit with dementia, Alzheimer's, or whatever other injury it is, it's too late. You can't do that. You can't sign something without having your full mental capacity.
Right.
Now, the dementia thing and the Alzheimer's, it's kind of a sliding sort of scale. It depends on where you are on the spectrum, right? You could be still competent while suffering the initial stages of Alzheimer's or dementia, right? You want to be able to know what your assets are, who your loved ones are, who should get your property and things along those lines. And so if there are periods where you're still competent, I would be okay preparing powers of attorney for you. But if there's, indications that you're not really playing on the same field as the rest of us, then I'm going to say you can't do it, and you're going to need to file for guardianship. Expensive, long process. Not terribly expensive, but more than preparing a power of attorney.
And how long would you say the planning for, applying for the guardianship, how long does that take?
It will take about 45 days.
Okay.
To prepare the papers, get a doctor's letter, get a court date, and then present the information to the judge before they can decide.
Okay, and that could all be avoided if they did a power of attorney before the person started showing signs of their mental issues, right?
Decline, sure.
Their mental
Yeah,
decline.
I mean, 100%, and that's the primary reason why you want to have the power of attorneys in place before that.
Yes.
And then you avoid all of that, because the same thing with a power of attorney for healthcare, you're not going to be able to make those decisions. Even if you're married, you're not going to be able to make those decisions.
Okay.
One other thing about the powers of attorney, especially the one for healthcare, it needs to get discussed with the family, because you could say, look, I want no extraordinary measures taken at the end of my life. If I'm not going to recover well, it's going to take too long, it's going to be too expensive, and spending all of our money on this without any reasonable hope that I'm going to get better. And you get to the emergency room, and the person with the power says, yep, we're ceasing further treatment, and the other 3 kids are like, hey, whoa, mom never told me that, or dad never said that. It becomes kind of a conflict, right?
Yes.
But if you have it in writing, and mom and dad have talked to the rest of the family about it and said, look, this isn't what I want, I don't want to be living on a machine, let me go. It saves arguments in the hospital, that's for sure.
Yes. It saves a lot of the drama that boils over, right? When family starts to dispute these situations.
Sure.
Yeah. So one quote that I thought was pretty funny was Ben Franklin said there were only 2 things certain in life.
True.
And it's not funny, but it's true. Death and taxes. And we can't avoid them, especially not in Illinois, the taxes, I mean.
Right.
It's so important for, like you mentioned, for family members to talk about this and to put it in writing and to talk to an attorney if they, at least to find out if they need a will, right? Or any other type of estate planning tools. I wanted to mention your website, which is lomap.com, LOMAP.com, which is really great. You have a lot of nice tiles that show all the services that you offer. And when you click on those tiles, it will take you to more information on how you can assist them. So great job, easy navigating into the website. So what about trusts? How do trusts work? I mean, I know that the will is similar to the trust, or is it a trust?
No, it's not a trust. 2 separate things.
Okay.
The trust is a legal document that takes effect upon your signature and upon your funding, right? So it's a device where you can take care of your assets and your estate right now. You designate someone to be the settlor, that's the person who creates it. And then you designate the trustee, who's the person who has the right to say, I'm going to buy this, sell this, or do whatever you can with the assets. And then you name beneficiaries. It says, after I'm done, I'm going to have a successor trustee. That's the person who's now going to be in charge after I pass. And then I'm going to name new beneficiaries. So it's going to be my wife and kids, or it's going to be my kids, or it's going to be the American Cancer Society, whatever you want, but it takes effect when you sign it. And the advantage of that document is that there is no probate, right? You pass, and the new beneficiaries are automatically named, right? And it goes right to there. So say, for instance, I have a house, I put it in trust. I'm the trustee, which I can decide sell it, finance it, keep it. And when I die, I want it to go to my kids. And it will then go in that direction.
So you're pretty much skipping any court proceedings.
Correct.
When you have the trust. Okay.
Correct. A will is a legal document that only becomes effective once you die. So that nice will that I prepared for you is a nice piece of paper, right? And every will you write, it says the last will and testament, and it's only your last will until the next one. So tomorrow, your wonderful children get on your nerves and you say, okay, you're out. You can change the will, and that one that you did 8 years ago is no longer in effect.
I see.
Once you create a new one, the old one dies.
I see.
And then they're both still just a nice piece of paper until you pass. Once you pass, it becomes a firm legal document that can be enforced in a court. Right now, I can't go in there and into court with your will because you're still alive.
I'm still here.
Correct, and they're going to say, "What are you doing? Get out."
What are you doing here?
Yeah, get out. Right. So let's just go back to the skipping the probate part. Right. In a will, once you pass, nothing has happened except you've passed and you've expressed your wishes. But you've said, okay, I want the house to go to my children. But they need someone to be able to sign the papers that transfers that property over to your children. Collect your assets, dig up all of your stuff. That would be your executor. So in addition, once you open that case, there's going to be a 6-month period where anybody who has claims against you can also make claims in the estate to say, okay, I want you to pay the funeral and the last hospital and any other bills you have. You might have credit cards that need to get paid or other bills. And
so that kind of stays open for 6 months?
At least 6 months, right? And sometimes it takes that long to gather things. At least part of that time is going to be appointing somebody to be the representative, the executor. And there's an expense to that, right?
Yes.
The will, relatively cheap. You get that for a couple hours of an attorney's time. The trust, on the other hand, is a lot of attorney's time. You're probably going to start, 4, 5, 6, 8 hours of time for an attorney at their hourly rate, where the will is going to be 1 or 2 hours. So you're doing that. You're also transferring property. So you have the expense of deeding your property into the trust. Trust can't give away what it doesn't own, so you have to put things into it before you can get them out. So the trust is more expensive in the beginning, but you avoid that period of 6 months where you have to wait to do things. Now, you don't avoid having to pay mom or dad's bills or credit cards or mortgage just because it transferred title according to the trust, but you still have to take care of those. You don't avoid any of that or any expenses, taxes, or the like that are revolving around the death,
okay.
Right? In the will, you pay a relatively cheap fee at the beginning, but then you're going to run into hiring the lawyer and going through the probate, which is going to be, again, more expensive. So sort of pay me now, pay me later, one or the other.
But it's called peace of mind, right?
Correct.
At the end of the day, that's what we are looking for with estate planning, is to have that peace of mind, which I was one of the reasons why we did that back 8 years ago. My son, who is now an adult, at the time was a teenager. And, when you're traveling, you never know what's going to happen. It was like, you know what, let's just get this paperwork in. Let's put it in a file, and God forbid it's needed, it's ready, right? So again, this is one of the reasons why I wanted to bring this up in the podcast, because not many people talk about it. What about people with children? How, what do they do? Just preparing a will through their attorney and including someone as a guardian to their children? Is that, the simplicity of it?
Yeah, sure. It's definitely something that you want to do. Especially if they're minor children and they're going to be minor for a period of time, right? Yeah. You want to say, who do you want to be in charge of my children?
Right.
You don't want them to be living in abeyance while somebody's trying to figure out, okay, mom and dad, had an accident. Now they're no longer here. Who's going to take care of my kids? So it's not an automatic appointment, but you get to designate who you want. And in your will, that would be something that the court would take as a number one choice, right? Anytime you make a designation in your will, the court is going to say, yes, that is their number one choice. We're going to do that unless there is some very, very good reason why we shouldn't.
Okay.
Right? And so you get to make those choices beforehand. And also, you can discuss it with people, right? You pick your favorite sister, brother, cousin to take care of your kids, and they know that they have a job to do in the future in the event that they have to. So it's not a surprise, and everybody's prepared. So yep,
Yes, communication.
You can do that. You definitely do. And I've seen a situation where they've not discussed it with the people that they are designated as guardians, and
Really?
they're going to, but they hadn't done it yet. And
Or maybe they like said it in a conversation, but they never really acknowledged, hey, you're in writing.
Right.
I did my will, and you're going to be the guardian if something happens to me.
right.
Okay.
Passing conversation.
Passing conversation.
Right.
I might put you in my will.
Take care of my children.
That's a big responsibility. Yeah, they should discuss that.
Yep. They should.
Awesome. So, is there anything else you'd like to mention about this topic that we may not have discussed so far?
Well, let's see.
Any other scenarios you can think of that might be helpful that you've run into in the...
Yeah, I think all of my worries come with communication. Again, where you do the document, but you don't tell anybody about it, right? And then it becomes a secret sort of thing where you have one of the 5 children taking mom or dad to the lawyer, and the others don't know about it, and it creates suspicion between the rest of them.
Yes.
I think that if you want to not give something to one of your children for whatever reason, that you definitely need a will to say that, right? I've given all of my children a piece of this estate except for, Joe, my other son, who I believe I've given all of, his share in advance.
Yes.
Right? So,
yes.
and then it's less of a blow when you get there and there's no mention. I've just cut out Joe and not said anything about it, right?
Yeah, I've seen in some scenarios where, and I would say more in the Latino family, where the grandparents want to leave something to the grandchildren. And they kind of like bypass their own kids for the grandchildren. It's that love of grandchildren.
Right.
So yeah, again, that's where it has to be in writing. Right.
Couple things about a will and or a trust. They are documents that are easily changeable. Say that with a caveat. There is an irrevocable trust.
Okay.
And that's above my pay grade, but there is such a document that you can transfer your property out of your name forever into a trust where you could still retain the use and benefit of it, but you don't own it any longer.
Oh. Okay.
That would be something you would talk about with somebody, again, who does a little more sophisticated estate planning than I do. I've heard of that in situations where you're trying to avoid paying Medicare or Medicaid, instead of, because their income limits. If you have too much property, have too much income, you may not qualify for those services, or you'll qualify for them, but they get reimbursed from your estate at some point. So an irrevocable trust is something that can avoid that, and I'm not exactly sure how that works. But a revocable trust and a will are documents that can be changed at any time.
Okay.
And they are, flexible, right? And if you have a house in the will and you're going to give it to your children, but you're still young enough to say, I want to sell the house, move to Florida, you still have the right to do that. It doesn't change your options because you've written it down that I want it to go to my children. Same thing with your car or any of your other valuables that are in there. If you pass and you've already sold that house, then the court just disregards it. So it's not a lock on what you can do in the future with your property. And same thing with the trust. You can change it at any time, amend it, change it, tear it up altogether. Don't know why you do that, but you could. There's no restrictions on that.
Okay. Wow. Well, that was a lot of great information, Mike. I really appreciate you taking the time to explain it, and I hope that the listeners can take this information, go to the website lomap.com, and take a look at not just all the legal services that you offer, but take a look at the information about the estate planning, because I saw there's a good breakdown of information on there as well. Your office number is?
773-772-8989.
And your email?
Michael, Michael, @lomap.com. That's LOMAP.com.
Got it. Awesome.
Thank you.
Thank you. I appreciate you being here, Mike.
You're welcome.
Hey, thank you so much for listening today. If you're watching on YouTube, please subscribe so you can keep up with my latest episodes. You can find me on all social media platforms at Dalia the Realtor. To reach me directly, call me at 773-879-4855. I'll see you on the next episode. Make it a great day.